Mr. Assistant Attorney General, what else can we do besides addressing the felony streaming issue? It seems like once we get that going, well, it seems to me like there's a under prosecution. Normally, I come to the committee complaining about overcriminalization, and now I find myself in the awkward position of saying let's make a felony of some of these misdemeanors. Can you give me some comfort in some way?
Thank you, Ranking Member Conyers, and I certainly prefer to be on a committee where you're recommending increases than the contrary. I think I can give you comfort because I think there are a number of ways that we can craft a felony penalty for streaming that is narrowly tailored to address the problem that we're seeing without sweeping too broadly into activities that should not be criminally prosecuted and are best addressed in other ways. One of those ways might be to craft a penalty that does not criminalize any new conduct that is not already currently criminal and merely makes felony penalties for conduct that is already illegal and can be criminally prosecuted as a misdemeanor. In other words, we would simply be increasing the maximum penalty that a judge could impose after hearing all the facts upon conviction. So that's one way we could certainly keep it narrow, and there are other ways that we could do that as well. Well,
now that I've found out where you stand on overcriminalization, are there other things that we might be thinking about? I mean, do all of you here think that we're making this a little too easy for plaintiffs to jump on the litigation bandwagon, and that we've got to find some ways to make it more difficult?
I don't think anything's easy for plaintiffs to jump on the litigation bandwagon. I think statutory damages are very critical to the individual creators because it empowers them to actually enforce their copyright and go to court. But what that empowers them also to is to make a reasonable settlement. But I think that for the individual, there's way too many hurdles, and it isn't simple enough.
We need to give the plaintiffs more assurance as small claims plaintiffs.
For the claims of relatively smaller value, there needs to be a more streamlined, efficient, less cost-consuming way to go to court. You can't spend up to $1 million if you really did a trial, or hundreds of thousands just getting through discovery and summary judgment when you're trying to collect $10,000, $20,000, or even $5,000. And attorney's fees aren't automatic either, so there's never a guarantee you'll get that.
Mr. Ranking Member, thanks. Sorry. I think when we talk about what is or isn't easy for plaintiffs, it's a mistake to lump all plaintiffs into the same boat, just as it's a mistake to lump all defendants in the same boat. There are plaintiffs for whom the current system makes the incentives to litigation a little too tempting to advance non-meritorious claims. I don't think that we are advocating eliminating statutory damages, but simply that the system adopts a one-size-fits-all approach to all sorts of different types of plaintiffs and defendants.
Mr. Bitkauer, how do you think